Simon Ekpa's court hearing in the Pyhäjärvi District Court in Finland is set to begin on May 30th, 2025, after no session was held on May 29th, 2025. 5 individuals have volunteered to testify against Simon Ekpa in court, including a close family member believed to be the older brother of Simon Ekpa's ex-wife. Dr. David Jono Matsanga, an international activist, publicly accused the Finnish government of colluding with Nigerian authorities and wrote an open letter criticizing Finland's President Alexander Stubb. Dr. David Jono Matsanga's letter, titled Formal Notice of Complicity, accuses Finland and Norway of double standards in Africa and has been circulated on social media, tagging global leaders. 4 out of the 5 individuals arrested alongside Simon Ekpa in November 2024 have been acquitted, but their frozen bank accounts and assets remain inaccessible, sparking criticism. The Finnish authorities have been accused of withholding updates on the acquittals, while Nigeria's President Bola Ahmed Tinubu and Defense Chief Christopher Musa are implicated in initiating the original charges. The United States of Biafra Deputy Prime Minister Dr. Ngozi Orubueze released a second batch of USB constitutions and independence declaration documents, complete with ISBN numbers and price tags for public sale. The USB now has an official national pledge, composed by Dr. Ngozi Orubueze and adopted by 20 USB cabinet members, marking another step in their symbolic independence. Meanwhile, Simon Ekpa's ex-wife has officially filed for divorce, distancing herself from him and his surname amid the ongoing legal proceedings. Also, a neighbor of Simon Ekpa had previously testified against him on May 27, 2025, submitting audio recordings as evidence, which were discussed in an earlier video. The unfolding legal drama surrounding Simon Njoku Ekpa in the Republic of Finland has taken on new dimensions, drawing intense public attention, diplomatic scrutiny, and emotional reactions from supporters, critics, and neutral observers alike. On the 30th day of May in the year 2025, the courtroom in the quiet Finnish town of Pyhäjärvi is set to reopen for what could be one of the most consequential hearings in recent memory concerning international activism, civil disobedience, legal diplomacy, and the question of identity. This momentous development comes after a brief pause in proceedings on the 29th of May, when no court session was held, leaving many in suspense. Simon Njoku Ekpa, a Finnish citizen of Nigerian origin and a self-declared leader of the United States of Biafra movement, has been a central figure in a highly controversial and multifaceted legal saga. His arrest in November 2024, alongside 5 others, drew sharp reactions from around the world, particularly from followers of the independence campaign he represents, international human rights observers, and members of the Nigerian and Finnish governments. While 4 of those arrested alongside him have since been acquitted and released, Simon Njoku Ekpa remains detained, facing allegations that are both serious and politically sensitive. The implications of this case go beyond simple legal arguments. They touch on the complex intersections of sovereignty, international law, national security, freedom of speech, and family betrayal. The Finnish government has remained relatively tight-lipped about the finer details of the charges, citing the sensitive nature of the case and ongoing investigations. This silence, however, has provoked backlash. Critics argue that transparency has been insufficient and that the actions of the Finnish authorities suggest undue influence from external powers, particularly the Federal Republic of Nigeria. One of the most vocal critics of the Finnish government's handling of the case is Dr. David Yonor Matsanga, a seasoned international activist known for his fiery rhetoric and unfiltered commentaries. Dr. David Yonor Matsanga recently released an open letter titled Formal Notice of Complicity, in which he accused the government of Finland and that of the Kingdom of Norway of perpetuating double standards in their dealings with Africa. Dr. David Yonor Matsanga's letter did not go unnoticed. It quickly spread across social media platforms and was shared widely by both supporters and detractors of Simon Nyoku Ekpa. In the letter, Dr. David Yonor Matsanga accused Finland of bowing to pressure from Nigerian officials, including President Bola Ahmed Tinubu and the Chief of Defense Staff General Christopher Gwabin Musa, to prosecute Simon Nyoku Ekpa based on politically motivated charges. He suggested that Finland's actions were inconsistent with the country's reputation for neutrality and human rights advocacy. The activist's letter was tagged to several global leaders and human rights organizations, signaling a plea for international intervention or, at the very least, scrutiny. What gives Dr. David Yonor Matsanga's intervention even more weight is his consistent history of advocating for African self-determination and his record of confronting powerful institutions. He referenced previous occasions where the Finnish President Alexander Stubb visited African countries and made promises that Dr. David Yonor Matsanga claims were hypocritical in light of recent actions taken against African political dissidents living in Finland. His letter also highlighted concerns about the manner in which the Finnish authorities have handled the assets of the individuals who were acquitted in this case. Indeed, this issue of frozen assets has sparked its own controversy. After their arrests in November of 2024, all 5 individuals, including Simon Nyoku Ekpa, had their bank accounts and assets frozen by Finnish authorities as part of the investigation. While 4 of these individuals have now been cleared of all charges during the preliminary investigation phase and subsequently released, their accounts and properties remain inaccessible. This has led to accusations of overreach and procedural injustice. Critics argue that maintaining such restrictions on individuals who have been acquitted creates an impression of guilt by association and is damaging to the reputations and financial well-being of people who are now technically innocent in the eyes of the law. Among the loudest voices demanding the unfreezing of these assets is the United States of Biafra. Deputy Prime Minister Dr. Ngozi Orabueze, who has been acting not just as a political leader but also as a spokesperson for what she describes as persecuted activists. Dr. Ngozi Orabueze condemned what she described as the silence of the Finnish press and called out specific newspapers that had initially reported the arrests but failed to publish updates on the acquittals. This silence, according to her, contributes to misinformation and fuels the perception of an unjust legal process. Dr. Ngozi Orabueze has used her platform to emphasize the psychological and economic damage caused by the freezing of assets belonging to people who are no longer under any formal legal suspicion. Amid this growing storm, the symbolic actions taken by the United States of Biafra movement have continued. Dr. Ngozi Orabueze has recently announced the release of a second batch of the United States of Biafra Constitution and Independence Declaration documents. These publications are now available for public purchase and come with international standard book numbers and price tags, a move that appears designed to give the documents a level of legitimacy and permanence. According to the official announcement, The United States of Biafra Constitution is being sold for $100, while the declaration document, which includes the signatures of individuals who endorsed independence from within Finland, is priced at $50. There are shipping arrangements in place for Europe, Nigeria, and the United States, reflecting the transnational nature of the movement's support base. More symbolically, the United States of Biafra now has a national pledge. This pledge, composed by Dr. Ngozi Orebweze herself, was officially adopted by 20 cabinet members of the movement during a formally convened cabinet meeting. The pledge is meant to be recited after the national anthem and is seen as a statement of cultural and political identity, reinforcing the group's claim to sovereignty and independence. The adoption of the pledge has been welcomed by many within the movement, but has also been criticized by those who see it as a further provocation to governments that do not recognize the legitimacy of the secessionist effort. As this complex political and legal drama unfolds, the personal life of Simon Nyoku Ekpa has also become entangled in public scrutiny. In what many observers have described as a strategic distancing, Simon Nyoku Ekpa's ex-wife has officially filed for divorce. This legal step not only dissolves their marriage, but also involves a formal disassociation from Simon Nyoku Ekpa's surname, an action that carries significant symbolic weight. Family members of political figures often face pressure and consequences due to public perceptions, and this move suggests that Simon Nyoku Ekpa's ex-wife is attempting to shield herself and her immediate family from the fallout of the legal proceedings. More remarkably, one of the witnesses who have volunteered to testify against Simon Nyoku Ekpa is reportedly a close family relative, believed to be the older brother of Simon Nyoku Ekpa's now ex-wife. This revelation has stunned observers and added a new layer of complexity to the court proceedings. In criminal or political cases, family testimony is often seen as particularly powerful, as it can indicate a betrayal of intimate bonds and provide the court with insider knowledge that external witnesses cannot access. The decision of this family member to come forward voluntarily suggests either a deep rift within the family or a firm belief in the seriousness of the accusations against Simon Nyoku Ekpa. The court is expected to hear this testimony in the hearing scheduled for the 30th of May. The exact contents of what this family member will say remain unknown, but analysts speculate that he may present financial records, personal communications, or even audio and video recordings that could provide critical insights into the case. The emotional impact of such a testimony is expected to be profound, both for Simon Nyoku Ekpa personally and for his followers, who may struggle to reconcile their loyalty to him with what is said in court. Earlier, on the 27th of May, another neighbor of Simon Nyoku Ekpa took the stand to provide testimony. This individual submitted audio recordings, presumably capturing conversations or statements that might have relevance to the charges at hand. While the exact content of these recordings has not been publicly released, the mere fact that neighbors are testifying against Simon Nyoku Ekpa suggests a degree of local concern or discontent with his activities. Whether these concerns relate to noise disturbances, suspicious behavior, or direct accusations of criminal conduct remains to be seen. However, the inclusion of such testimonies shows that the case against Simon Nyoku Ekpa is not solely political. It includes personal, social, and community-based dimensions. The stakes in this case could not be higher. For the Finnish government, the credibility of its judicial independence is on the line. It must navigate between upholding its domestic laws, respecting international human rights standards, and resisting any perception that it is acting under pressure from foreign governments. For the government of the Federal Republic of Nigeria, the outcome of this case could set a precedent for how diaspora activists are treated abroad. Nigerian officials, particularly President Bola Ahmed Tinubu and General Christopher Gwabin Musa, have an interest in demonstrating that efforts to destabilize the country through external platforms will not go unchallenged. For Simon Njoku Ekpa himself, this trial represents a personal and political turning point. If convicted, his influence could be diminished and his reputation severely tarnished. If acquitted, he could become even more powerful as a symbol of resistance, martyrdom, and diaspora nationalism. The presence of hostile witnesses, including a former family member and a neighbor, complicates his defense strategy and places his personal credibility under intense scrutiny. For the United States of Biafra movement, the legal battle serves as both a rallying point and a moment of reckoning. On one hand, it galvanizes support, drawing attention to their cause and framing Simon Njoku Ekpa as a persecuted leader. On the other hand, if the legal arguments against him are persuasive and credible, it could lead to internal divisions and a rethinking of leadership and direction. The release of constitutional documents and the adoption of a national pledge are clear attempts to cement the movement's legitimacy, regardless of the trial's outcome. As the court prepares to hear more testimonies, the international community watches closely. Journalists, legal observers, human rights organizations, and government officials from several countries will be monitoring the proceedings, aware that this case is not just about one man, but about the broader principles of justice, sovereignty, and civil activism. Whatever happens in that courtroom in Pyhäjärvi, the ripples will be felt far beyond the borders of Finland. In many ways, the story of Simon Njoku Ekpa has evolved into a modern tale of resistance, power, family betrayal, and ideological struggle. The next chapter, which will unfold in the Finnish courtroom on the 30th of May, will be critical in determining how that story is remembered and what it ultimately means for the people involved and the causes they represent. As the clock ticks toward the anticipated court session on the 30th of May in the quiet town of Pyhäjärvi in the Republic of Finland, anticipation and uncertainty continue to swell across continents. The case against Simon Njoku Ekpa has evolved into something far beyond a conventional trial. It has become an emotional and ideological theater where questions of power, family loyalty, national identity, international diplomacy, and legal ethics are being played out. The courtroom may be small and located in a town rarely mentioned in global headlines, but its walls are now bearing witness to events with implications that stretch from Helsinki to Abuja, from Oslo to Washington, and from the bitterly divided communities of the southeastern region of Nigeria to the heart of the Finnish judiciary. The sudden re-emergence of the case on the judicial calendar after a day of silence on the 29th of May has set social media ablaze. Speculation over what might have caused the pause on the 29th ranged from procedural deliberations to diplomatic interventions to the preparation of new evidence. For supporters of Simon Njoku Ekpa, the day of silence was interpreted as a sign of possible interference or indecision within the Finnish prosecutorial system. Many of them expressed concerns that there might be behind-the-scenes negotiations being held between Finnish officials and their Nigerian counterparts. Others wondered whether the unexpected break was used by prosecutors to finalize witness protection arrangements for the relative who has reportedly agreed to testify against Simon Njoku Ekpa in the next hearing. As this court case grows in complexity, so does the legal apparatus surrounding it. According to emerging reports, Simon Nyoku Ekpa's legal team has filed a motion requesting the immediate unfreezing of the bank accounts and assets of the 4 co-accused individuals who were acquitted. The legal team argues that continuing to hold the assets of people who are no longer under any formal investigation or indictment violates principles of justice and due process. The motion references specific articles of Finnish law and international human rights provisions that prohibit the continued deprivation of property without legal justification. Furthermore, Simon Nyoku Ekpa's defense team has signaled their intention to challenge the admissibility of certain testimonies, particularly that of the family relative who is expected to take the stand. Their argument appears to hinge on the nature of the relationship between Simon Nyoku Ekpa and the witness, asserting that the testimony may be colored by personal resentment stemming from the now public divorce proceedings initiated by Simon Nyoku Ekpa's ex-wife. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.